Welcome, esteemed viewers, to my Equity and Trusts 2 series. That is the law of trusts. Today's topic is classification of trusts. Classification of trusts is what this particular video is all about. So, what is the objective, or what should be your expectation at the end of this video? You should know how trust is classified. How trust may be classified. You should also be able to explain each of these classifications. Should know what each of the classification entails or connotes. Before I start the discussion properly, I would love to make some comments on the first video on law of trust, which is on the meaning and nature of trust. The first comment is about the observation of Maitland on trusts. It was mentioned in that video that Maitland observed that trust is the greatest achievement of English courts in the field of jurisprudence. That word court is not the appropriate word there. The appropriate word is Englishman. That's the word is used, that it is the greatest and most distinctive achievement of Englishmen in the field of jurisprudence. So take note. Then secondly, in my explanation of the meaning of trust, I so much confine the meaning to where a person gives property to another to hold it on trust or to keep it for the benefit of another person. Take note that trust does not only arise where a person on his own actually gives property to another person to hold it for another person. Trust can still arise even where the set law does not give the property to the trustee to hold on trust for another person. That is, trust can still arise by operation of law. The law can still say that there is trust here. This is a trust, even when there is no set law giving property to any person. That's what I also wish to add, that it is not only when a person, a set law, gives the property to the trustee, it can still arise by operation of law. That is why Keating said that it is when a person is compelled in equity. So a person can be compelled to be a trustee in certain situation, even when the set law did not deliberately give the property to that person. Then about another, finally, is on another name for the beneficiary. I made the mistake that although I corrected it by writing it, that another name for the trustee is the certificate trust or the certificate trusts. It is not another name for the trustee, it is another name for the beneficiary. And sometimes you might be seeing that seti or sestui, you might be seeing s at the end. Sometimes you may not see s. When you see s, there's the plural form. So there's the few comments. So now let's come to today's one, which is classification of trusts. How is trust classified? What are the various classes of trusts? First, it is important to also state that just like with definition, another task which is not easy in law or with respect to legal concept is classification. There is there's usually no watertight classification of legal concepts. there's usually no perfect way to classify legal concept. That is why when you look at the various classification, for instance, law, there's endless classification to law. You will classify it this way, you classify it the other way. So take note that there's usually no watertight classification of any legal concepts. As we shall see, the classification of trust, they are not in watertight compartments. They are not perfect. The classification is not perfect in that they overlap. The classification, a particular classification can still fall under another classes. So just take note of that first. However, for classification of trust, there's actually the common classification. So there is common classification of trust, the general classification, the most common classes of trust. So there are some classes of trust that if you are asked to discuss the classification of trusts and you don't mention those one in your classification, then you have not started. But there are some that if you not even mention those one, then you can still be awarded a better grade. For instance, if you are talking about the classification of trust, you didn't mention express trusts and implied and resulting trust, constructive trust, or public and private trusts. Those ones are the most common classification, and they are the most important. Those are the important classification. In fact, anything classification, you will always have one aspect of the classification that you can still put every other classes inside that classification. For instance, from my own view, the major classification here is just express and implied or resulting trusts. Every other classification can be grouped under these two classes. So what are the most important and common classification of trusts? The following are the most important and common classification of trusts. They are usually just like every other classes too of legal concepts. Most legal concepts, they are usually classified in pairs. They are usually in pairs, and those pairs, they are always in contradistinction to each other. For instance, public and private law, criminal and civil law. The same thing with trust. The classification in pairs, apart from one that is a have three classes in that group. Otherwise, most other classifications are in pairs. There are two in each class. So what are the classification? The following are the classes of trust. We have, or there is, what is referred to as express. So we have express trusts. We have implied or resulting trusts. We also have constructive trusts. Then we have private and public trusts. The first classification, they always go together. Express, implied or resulting trust, and constructive trust, they are always discussed together. So that's one set. Then we have public and private trusts. Also, we have what is referred to as executed and executory trusts. We also have trust of perfect obligation and trust of imperfect obligation. That's another classes of trusts. Then we have completely constituted trust and incompletely constituted trusts. Those are the major and the common classification of trust, but they are not all. For instance, there is still protective trusts, secret trusts, and then discretionary trust. So the classification is actually endless. So let me see if I've mentioned the one we are concerned here with: express, implied, constructive, private, public, trust of perfect and imperfect obligation, executed and executory, then completely constituted and incompletely constituted trust. So those are the classification of trusts, the most important and major classification. Now, for the purpose of today's topic, we are not going to discuss them in detail. In fact, some of them are not detailed, but there are some that will still be discussed in detail. So for today's video, we just have a general overview of all these classes. Then subsequently, we shall now start discussing each of the various classes, some of them specifically in detail. For instance, express, implied or resulting or constructive will be discussed specifically in detail. Public and private trust will be discussed specifically in detail, and the public trust will also be discussed specifically in detail. But for the purpose of this video, just have a general overview and understanding of them. Then subsequently, those ones that are that will be specifically discussed in detail, we shall now discuss them. So let's look at what they entails generally. For proper understanding and or comprehension, for easy comprehension, I have grouped all these classes of trust I've mentioned. I've grouped them into 18, or I have used some criteria to classify them. I've grouped the classification into various 18, or I've used some parameters to classify them. So we shall discuss them under those 18. So the first 18, this 18 will help you to understand the various classes. So for instance, if you can recall the aid, then you will know the trust under them. And the aid, how the aid is tagged, is actually an explanation to those classes of trust. So number one, I have classification according to how they are created. So classification of trusts, my number one criteria of classification, which can aid you, your understanding of the various classes, is classification according to how the trust is created or how it arises. Let's say my number one pattern of classification. And under this class, we have express trust, implied or resulting trust, and constructive trust. So these trusts, I classify them as classes of trust according to how they are created or arises. And that's what we shall see as we explain what they mean. So first, express trusts. What is express trust? Recall express contracts. So when something is said to be express, it is clearly stated. So express trust is a trust that is created by the acts of the settlor. So it is a trust that is created by the act of the settlor, either inter vivos, that is during his lifetime, or by will. So there is a express trust. So express trust is a trust created by the acts of the settlor, either in his lifetime or by will. Now, what is the, what are we trying to say? Express trust is created by it is created intentionally, deliberately by the settlor or donor, by the owner of the property. So the owner of the property creates that trust deliberately. The trust comes into existence or arises because of the acts of the owner of the property. So the owner of the property must take some step in creating that trust. If he did not take that step, the trust will not arise. So it arises from its own acts. When the owner of the property will declare himself, will either declare himself as a trustee of the property for the beneficiary, or will transfer the property to another person to hold on trust for the beneficiary or beneficiaries. That's how that's when a trust is said to be express, when it is created intentionally or deliberately by the settlor or donor, and he creates it either in his lifetime or by will. So trust can be created during a person's lifetime, and that would be by declaration, by declaring himself or to be a trustee to the beneficiary of his own property, or by conveyance, transferring the property to another person to hold on trust. That's when a trust is said to be express trust. Then implied or resulting trusts. Implied or resulting trust, that trust, implied or resulting trust and constructive trust, they arise by operation of law. So in those trusts now, it is not by the deliberate or intentional acts of the owner of the property, but by the operation of law. Something is said to arise by operation of law when the law stipulates that whenever a given circumstance is present, then this is what will necessarily follow. So when the law says that if this happen, then another thing will happen, then it's said to be by operation of law. So for instance, if a person can say to maybe for instance, if it is let's use a landlord in mode of acquiring title to land, one is by operation of law. So by operation of law is where the owner of the property dies intestate and is subject to customary law. The property automatically becomes a family property. That's by operation. So the operation there is that once the person is subject to customary law and he dies intestate, then the property automatically becomes a family property. There's a way of acquiring family property, and it is by operation of law, because the law states that once this happens, then this is what will necessarily follows. That's when something is said to be by operation of law. So constructive and implied trust, they are by operation of law and not by the act of the donor or the settlor or the owner of the property. So now, what is implied or resulting trust? Implied trust is a trust that arises by the presumed intention of the settlor or the donor. So implied trust now is a trust that arises from intention that is presumed, not actually from the act of the owner or from the actual intention, what the person actually intends, but this intention is presumed by law. The law presumes that to be the person's intention. So whenever there are some certain circumstances that once it is available, then resulting trusts will arise, and it is arise based on the presumed intention of the owner. For instance, one of the circumstances where resulting trust, which we shall look subsequently when we look at it properly, one of the circumstances resulting trust arises is where the interests of or where express trust fails, or where the interest in the trust property is not fully disposed. So where there is an express trust, a trust that is deliberately created by the owner of the property, as we shall proceed, there are circumstances where that trust will fail for not meeting up certain requirements. So in some circumstances where that trust fails, the law will now it will be presumed by the law that the owner of the property intend that to become a resulting trust or an implied trust. There will be a resulting or an implied trust where an express trust fail. So it is created based on the presumed intention that this is what the owner intend for it to be. This is what the owner intend for to be the outcome. That if this express trust fail, and that intention is given to the person by the law, because it is a presumption and it is rebuttable. So just take note that express trust arises based on the presumed intention of the settlor, or donor based on the presumed intention of the settlor or donor. Let me see if there's anything important that is missing there. Yes, so from the presumed intention of the owner of the property, let's just say all. Then constructive trust. Constructive trust is a trust that also arises by operation of law. It arises, it is a trust imposed by equity, imposed by law, irrespective of the intention or intentions of the owner of the property. So constructive trust is imposed by law. It is the law that imposes it on the trustee, when the law will treat a particular person as a trustee, that you are a trustee. So not regardless, in this case the law does not take the intention of the owner into consideration. For express trust, it is actually based on the intention of the owner. It is created based on the act of the owner and intentionally. But for implied, now for implied, it is created based on presumed intention. So you can say that for express, it is actually based on the actual intention of the owner, while for implied, it is based on the presumed intention. But for constructive, where there is no presume and there is no, the law does not take those one into consideration, does not take cognizance of the intention of the owner, whether it is presumed or not. The law will impose it on the trustee. The law will hold the trustee, will treat a particular person in certain circumstances as a trustee. So that, as we shall see, there are areas where the law will treat a person as a trustee. So if you are just happy, jubilating that, oh, you want to take a advantage of of something, you want to make maybe a secret profit, you are happy within yourself, oh, you will not know. The law can see you. The law will own you as a trustee. So that one, it is, if you have to be colloquial, constructive trust is like a kind of by force. The law will compel you to be a trustee, and the essence is usually to avoid injustice, to avoid unjust enrichments. So constructive trust is a trust imposed by equity on a person, on the trustee, irrespective of the interest. It's when the law will declare you to be a trustee of a given property, or of a given profit, or of a particular thing, irrespective, regardless of the intention of the owner of that property. So there's the first classification. Then another classification I said is classification according to the number of persons for which benefits the trust is created, or according to the purpose for which the trust is created. So you can classify trust according to the number of persons who will benefit from it, or according to the purpose for which the trust is made. And under this, you have public trust and private trusts. So private trust and public trust, I classify them under the heading according to the number of persons for whose benefit the trust is created, or according to the purpose for which it is created. And so private trust is a trust that is created for the benefit of a person, or a class of person, or a group of person. So private trust is created for the benefit of a person or a class of persons. So the purpose of private trust, it is created, in fact, it is created for private purpose. So it is a trust that is created for private purpose. Now, public trust is a trust that is created for the benefit of the public. It is also known as charitable trusts. So it is a trust that the purpose is charitable. So it's a trust created for charitable purpose. So it is the purpose is for charity, to do charity. So that's why I classify them according to the purpose for which it is created. And as I said that the classification, they are not watertight. For instance, this public and private trust, you can still classify them under express as express public trust and express private trusts. Then classification according to the nature of beneficiaries, according to the kind of beneficiaries. Here I group trust of perfect of obligation and trust of imperfect obligation under this heading. So once you know the heading, the explanation will not be difficult to you. So according to the nature of beneficiary, trust of perfect obligation and trust of imperfect obligation. So trust of perfect obligation is a trust that has human beneficiaries who can compel the performance of the trusts, who can compel the enforcement, who can take steps to enforce that particular trust. So when trust has the beneficiary, the object of the trust is human, like in our maiden video, I mentioned that the beneficiary or the object of the trust may not necessarily be human. It can be created for non-human objects. So if the beneficiary is human, that trust is also regarded as trust of perfect obligation. And the important point is that the beneficiaries can compel the performance, can compel the trustee to perform the trust, or they can enforce the trust. Then when the trust does not have human beneficiary who can enforce the trusts, then that is trust of imperfect obligation. Imperfect, the obligation cannot be perfected, so it is an imperfect trust of imperfect obligation. So if a trust is created, for instance, there is a trust created for maintaining the integrity of newspapers. That was what that trust was created for, and it was a trust of an imperfect obligation. And very importantly, trust of imperfect obligation, they are generally void. So because they cannot be enforced. However, the only exception is public or charitable trust, which can be enforced by the Attorney General. So it can be enforced. So if a trust is created for an object other than human beneficiaries, that trust generally is void unless that trust fall within the class of public or charitable trust. Otherwise it is void, because no one can take step to enforce it, since the beneficiary is not a human. So trust can be created. The object of a trust can be non-humans. So for instance, trust has been created to maintain a tomb. Someone has created a trust to maintain a trust. So it must not necessarily be human. Then in classification, according to whether the details of interest of each beneficiary had been specified. So under classification according to, so I have another heading, classification according to whether the interest of the beneficiary had been specified. Then under that we have executed or executory trusts. So we have executed or executory trust. So a trust is said to be executed if the testator or settlor do not has actually specified the interests which the beneficiaries are entitled to. If under a trust, the settlor, the owner of the property, has actually indicated the value of interest in which a particular beneficiary is entitled to, then that trust is said to be executed. But where that is not done, but the beneficiary, the owner of the property or the settlor, just leave a scheme for the trustee, just leave a scheme of settlement for the trustee to decide, then that trust is said to be executory, because the interest of the beneficiary is not indicated, but it is left for the trustee or trustees to decide. That is why it can be boldly said that discretionary trust can be said to be an example of executory trust. Then the final classification, the final heading of my classification is classification according to whether the necessary steps have been taken to vest the property in the trustee. So I have another heading of classification, which is classification according to whether the necessary steps have been taken to vest the property in the trustees. And here under that I now group completely constituted and incompletely constituted trust. So under that heading you have completely constituted and incompletely constituted trust. So a trust is said to be completely constituted when the testator or the settlor or the donor has taken the necessary steps to vest the property in the trustee or trustees. So when the settlor or donor has actually transferred the property to the trustees, then it is said to be completely, as the name implies, constituted. Completely constituted. So if it is a land, the settlor has actually executed the deed of mortgage, the deed of conveyance, or the deed of assignment, any relevant document to be executed, and it has been executed by the settlor, then the trust is said to be completely constituted. But if it is the property, he has not taken the necessary steps to vest the property in the trustees, then it is incompletely constituted. For instance, if the settlor has actually, for if it's a share in company, and the settlor as in the trust instruments given its share to be held on trust for the beneficiary, and he has not transferred, taking in transferring your interest in a share, there are some steps you must take. In doing that, you must execute some documents to actually transfer the share, so that some changes can be done, and it will be indicated that you are no longer the owner of the share. So the settlor must, when he has taken all the necessary steps and has done everything required to actually transfer, not just the clearing, but to actually transfer the interest, to actually vest the property or the interest in the trustee or trustees, that is completely constituted. So if it's just a promise, if for instance the settlor or the donor promise the trustee that he will transfer the property to him so time, then the trust is here to be completely, in that case that trust is incompletely constituted. And what is important is that if the trust is completely constituted, it is at that time that the beneficiary or beneficiaries can actually enforce that trust. But if it is here to be completely constituted, what will you enforce against the trustee? The beneficiary in that case can only enforce it if he furnished consideration. If the trust is incompletely constituted, it cannot be enforced unless the beneficiary furnish a consideration. So this is the general overview of the classes of trusts and the major classification of trusts. In the next video, we shall now start looking at some of these classes specifically in detail. For instance, we shall start with express private trusts. Express private trusts. So don't forget, if this is your first time of seeing my video, to subscribe is very important. Thank you. And don't forget to also watch the full videos, all the videos on the topic, so that you can get a full understanding of it. See you in the next video. Thank you.